think real estate agents can really help out a lot of homeowners in kind of discussing their options and trying to figure out, why are you in foreclosure, and kind of here's the reality of the situation. Yeah. Right? You need to sell.
I would also imagine a large portion nowadays of people who could also be eligible for, selling it and avoiding foreclosure, because there's so much equity in most people's situations.
Yeah. And so a lot of times they don't like accepting that reality, that maybe it's too much house for them. And I've had that conversation with a lot of people before, right? Yeah. Like, listen, this is just too much house for you, and it's okay. You need to downsize, and you have all this equity, which is great. But if you try to fight this legal battle with the bank, unless you have the proof, unless you have the evidence, you might not, it's very likely you're not going to be happy with the outcome here, right?
And then you're losing the house and you have the attorney.
You're spending money on us, you're racking up a bigger bill that you owe the bank, because arguably, right, especially in pre-foreclosure, arguably all the attorney's fees that the bank spends fighting your lawsuit is just going to be added to the bill.
So for them, that is kind of a double-edged sword.
Yeah, you really have to choose your battles if you're in pre-foreclosure, right, in suing the bank.
Yeah, because there's probably not a huge portion that are even short sale eligible, because most of them have an equity position at this state.
Yeah, which is a good thing.
Yeah.
When I got started, everyone was upside down, so it was like, hey, you got nothing to lose.
Yeah, I'll fight this.
Already, more than the bank's going to be able to recover on. So you strategic kind of position to be in too, right? If you're upside down in your home, it's kind of like you got nothing to lose. You might want to just file that lawsuit and maybe force the bank to start really entertaining some cash for keys, some short sale option, right? And that's where the real estate agent can come in and help
streamline that process for you. When you deal with the short sale like that, not short sale, foreclosure, the first thing I thought when you mentioned it is, for them to be able to pay for your services means that you have at least some capital. So they should be able to at least delay the foreclosure or make certain payments to keep the bank at bay. Or is that a false presumption?
Yeah. Well, I mean, they should, right? I mean, if you're not paying your mortgage for a year, 2 years, right? Hopefully you've done the wise thing of saved a lot of that money. And then you end up using it to, pay for your attorney if that's the route you want to go. There's, bankruptcy, you could do a Chapter 13, option, and you get into a payment plan, right? You get into this official payment plan that the government allows you to have the right to. And, like you said, if you're in pre-foreclosure, you want to have some good faith settlement money to pay the bank. Like, here's $15,000, for this loan mod or forbearance plan or something to work out.
Will most banks work with some kind of strategy, either extending the loan time to kind of recast the loan to make it a possibility, or what's the likelihood?
I think if you're working with a bigger bank, right, one of the big main banks, then yes, they would probably be open to the idea of extending, your loan and modifying your loan to figure out a solution. Banks aren't in the business necessarily of foreclosing, but then if you have kind of a smaller lender or just one of these mortgage servicers that are known for
some have the
foreclosing, and Susan can go and talk to you more about servicers and all that issue, but I mean, she'll even tell you, servicers are, make their money from foreclosures. So,
but
their boss is the bank that owns the note. But some servicers, really are in the kind of the business of just charging fees and
And I take it you probably, since you've been in this a while and it's an area of expertise for you, you can probably see this servicer will probably work with us, this one, from a quick look at a file, you're like, we have a shot or we don't, based on just who the servicer.
Yeah. I mean, I think in the industry, we all kind of know which servicers, are like, yep, nope.
The reputation.
Nope, they're going to foreclose on you, I mean, again, if it's coming straight from Chase or straight from Wells Fargo or B of A, you're generally going to be okay with trying to, entertain a loan mod, but, maybe it's Mr. New Res or Mr. Cooper, then you're like, not so much.
Not as high of a probability.
They're a professional servicer.
Got it. Okay.
Yeah, so one of the other things that was listed on the topics that I thought that you had brought up for us was, sellers and buyers, right? Buyers and sellers, what happens when they kind of disagree or when a seller doesn't want to? And I thought that was an interesting, because it comes up a lot.
Yeah.
Right? So I don't know if you've seen that.
I've seen it, and it's an interesting thing because that classic example, like here's contractually what you're supposed to do, and then there's reality, which doesn't always coincide with it. Mm-hmm. What does that process typically look like? Is it normally finding a middle ground? And then I would love to get your sense on, in the RPA, we have the liquidated damages paragraph you have to sign, the mediation is automatic, and then there's arbitration.
Yeah.
What's the stance of an arbitration?
Yeah.
Like, if you were buying a house, would you sign arbitration or would you not sign arbitration?
Yeah. So generally, I don't like signing arbitrations.
Okay.
Because that's why it's a big old clause, right? It's like you're giving away your right to a jury trial. And so that could be very powerful, right? As a regular person, as a regular consumer, you in most circumstances, like if your doctor like botches your procedure or something, your dentist botches something, wouldn't you rather put that in front of a jury? Right? To figure out how much that person owes you, right? So with general contractors, right, I've refused personally to sign arbitration clauses with like contractors because I'm like, hey, if you screw up my home, I want to go to a jury, right? More pressure. But I guess in the buyer and seller context, they're both, on the same playing field, right? Yeah. They're both ordinary people. Signing the arbitration clause probably doesn't have a big effect, right? It could maybe save some costs.
Yeah. Because to me, I think the biggest advocate for it, and tell me if I'm misinterpreting it, is a time element. Litigation will take roughly, up to 2 years if you go the whole length of it. Whereas arbitration, you can probably get it resolved within 4 to 6 months, I would imagine.
Yeah,
so
exactly.
If you don't want to have this tied up indefinitely, and most cases end up settling already, right?
Yeah. Regular state court litigation, 2 years, right? With all kinds of discovery. It's all very formal. There's lots of formal motions that you end up filing, so the costs are very high. So arbitration costs, yes, they're lower, and generally it's this informal exchange of information and documents. The arbitrator kind of makes sure that is happening between the parties, and then the arbitrator has like this one-day hearing, for a car dispute, right? It's usually going to be a one-day hearing, and then issues a ruling. So it's very quick, and you save money as opposed to on your attorney's fees. If there is a dispute between a buyer and seller, there's the steps that you have to follow, right? So your real estate agent and broker should be aware of sending those demands, demand to close, right?
Notice to perform the contingency.
Notice to perform, exactly. Waive your contingencies. So, that's, one of the benefits of hiring experienced, agent and broker, not just, your neighbor, right? And then for the legal side, right, as attorneys, we are usually called in. We get the call when there's an absolute breach. And then we start saying, okay, here's the demand for mediation / arbitration if the arbitration clause has been signed. And so let's say the seller's refusing to sell, then the buyer has to send that demand. If you don't send the demand for mediation, then you're losing potentially your rights to recover your attorney's fees if you win.
Yeah. And is that true on both? If you say you sign mediation and arbitration, you offer mediation, they ignore you, and you go straight to litigation. Are you risking losing your recovering attorney's fees because you didn't also propose arbitration, or because they didn't respond to mediation at that stage, you're allowed to kind of pivot to litigation?
Yeah, so the car form attorney's fees clause is for the mediation requirement, right? So you do have to, send the demand for mediation. And then if they don't respond, then you move on to the next step. Now, whether the next step is arbitration or state court, you've satisfied the attorney's fees, right?
Portion.
Yeah, you protected your right to attorney's fees by doing the mediation. Now, what happens if you don't do the arbitration and you kind of like skip ahead to civil court, state court, but you haven't done the arbitration demand and you sign off on arbitration? The other side could go ahead and force you back into arbitration, and then recover their fees
for forcing you
into arbitration. So you don't want to do that, but you won't waive your right to attorney's fees.
So let me ask you this, because in America, there's this perception that you can litigate anything, regardless of what a contract is. If someone goes to arbitration and they just hate the end result and they try to fight it, I'm sure you've seen that. What happens in that stance? Or is it just like it's kind of a dead case because you've taken the steps, the contract said it, and you can fight it, but your likelihood of a victory is slim?
So you're saying like if they've lost at arbitration? I mean, me personally, if a potential client came to me and said, hey, I lost arbitration, I want to like take this to the next level, I wouldn't take the case. It would be frivolous in my opinion. It's very, very slim that an arbitrator has abused their role in the process, but they have such wide discretion. So, and that could be good or bad too, right? I mean, an arbitrator, maybe they just didn't like you, and they're and they didn't believe you, right? When they didn't believe your testimony, and they didn't find you credible, and that goes into their ruling, and so you're kind of just, loose.
And then the general perception of mediation is, finding a common ground that everyone's least unhappy with, really. Do you think there's a large enough success where people will be satisfied with mediation, or do you think most people go through it because it's a step and it ends up in either arbitration or litigation?
I think most people should settle at mediation.
Okay.
And you do have to go in to be successful and for your own benefit. If you find yourself in mediation, I think you should accept that you're not going to be totally happy, right? That means there was a good mediation, right? Oftentimes there's an overlap where both parties, if it settles within some range, then it makes sense. It makes like objective sense. Now, your job is obviously to try to pull the other party as close within that range to you, where you maximize your benefit in mediation. But nobody's ever really going to be happy with the outcome.
A commonality of
you have to give up something.
Is there a statute on the purchase agreement with the mediation arbitration? Say you bought a house, and 2 years later you find out, hey, the seller just didn't disclose this, and this is a material fact to me. Do you still have to go back to, hey, I want to do mediation, arbitration, or is there an element when it lapses where you can just be like, I'm going straight to litigation?
For failure to disclose and stuff. So you got to do the mediation, right? You got to send out all those notices. It's a cost benefit analysis too, right? I mean, those cases are hard. I think we have another attorney who can definitely go into more detail on that whole rabbit hole of disclosures. But we have a lot of cases right now, right, where foundational issues. One case we're working on was where we had a palapa. An illegal palapa in the backyard. So there's really nice barbecue setup, like a tiki kind of lounge setup, but it was all constructed illegally.
All unpermitted, things not to go.
And they didn't disclose, right? And the homeowner knew that they didn't do this with permits, and so failing to disclose that, has resulted now into a very expensive lawsuit for the seller. We were looking at $250,000 because they're going to be responsible for my client's fees, attorney's fees, and my client having to demo and rebuild this to code. Which is like, it's just crazy. So to save maybe, a couple, maybe $20,000 to $30,000, right? Because they didn't want to get the permits and maybe do it the right way. Now it's going to cost them 10 times that.
To piggyback on the permit one, because that brings up a question that comes up fairly regularly in my space, is, hey, we have this bathroom or this build-on that was all unpermitted. If the seller discloses it and discloses it fully, top to bottom, hey, we had this amount of square footage built, the walls weren't permitted, the plumbing wasn't permitted, like full disclosure. Is that going to suffice afterwards if something comes up with it, or can that buyer still come towards them and say, hey, your unpermitted work has created an issue for us?
I would say they're probably, depends, but they're probably protected. As a seller, your main duty is just communicating any and all issues to the buyer, and then it's to them. But now it's kind of as is, right? You're buyer beware. You're buying it with these potential problems that could happen, and it's up to you to decide if if the price is a worthwhile price.
And I think about, when you say that, the first thing I think about is in the contract where it clearly states every property in California sold as is at the close of escrow. Yeah. And the only difference there is if that something was not disclosed.
Yeah.
But it's like if you clearly defined, hey, here are the issues, you know about it, it's kind of at that point the buyer chose to take on the risk.
Yeah, yeah. And it's also, the sellers are also responsible for what they should have known. Mm-hmm. So I think that issue comes up a lot too. It's like, oh, I didn't know. Well, I mean, you should have known. That's not a defense. You're the homeowner. You lived there for 10 years. So I think as a seller, right, maybe that's something that you should discuss with your agent. Doing maybe your own kind of investigation of what's been going on, and have that conversation with your real estate agent of, hey, there was that one leak that happened 5 years ago, and maybe I should make sure there's no mold, in this corner or something.
And even just that clear disclosure, I think so often people want to just rush through those disclosures so quickly they don't mention. It's like you said, if there was a leak 5 years ago, even if you believe you fix it, state it. Because if there's something that came from it that you aren't aware of, at least you've put it out there that it was a known thing.
Yeah. And then also with buyers and sellers, with a lot of questions that I get is, on the buyer, my potential client is the buyer, and they're like, the seller's refusing. So, what do we do? And, can they just, refuse to sell? Well, like, once the contingencies have been waived, once you're all scheduled to close on time, close escrow on time, and the seller is kind of, they've signed. Yeah. They're in that contract. Seller, in my opinion, the seller, in my opinion, has less options, right, than the buyer. A buyer typically has a lot more options with their contingencies, to back out cleanly, and get their deposit back. But I was talking with one of my colleagues, and we were talking about how interesting it is when there's an FHA loan, and then a seller refuses to do the repairs. Yeah. Right. If there's a repairs request per the loan, what can the seller go and just refuse? And we think maybe there could be some legal argument that's not frivolous that the seller should do some of those repairs. But I mean, in practice, I think that's kind of one of the ways a seller backs out. Hey, I'm not going to do any repairs. I just want to do this as is. And then, as agents, maybe if it's only $4,000 or $5,000, maybe the agents get together to be like, listen, we'll cover those costs.
We'll find a way to make this move forward. Speaking of FHA, and I just love how natural we can just kind of run through different theories here. FHA carries with it the FHA VA a mandatory clause, and there is a different positions within my industry of the validity of what that means. Some will state that, hey, if you waived your appraisal contingency, you waived your appraisal contingency. Versus others state, hey, FHA doesn't really give you the right to waive your appraisal contingency, and if it doesn't appraise for this value, you still have the right to walk away. Have you encountered that, or? I
mean, that's an interesting argument. I haven't personally encountered that. I mean, I think just from my gut, without researching it, that if you're waiving the contingency, you're waiving it. Now, in practice, probably why I haven't come across it as often is because most escrow officers, lending officers are going to be very aware of this issue. So they're not going to go ahead and let you, right? They're not going to give you the green light to waive that contingency unless everything is totally ready and good to go. But obviously that's something that's very important for both homeowners and agents to be aware of, to triple check, right, that authorization from the loan officer, and especially if it's a VA, FHA that has extra requirements, is this loan good to go? Are we ready to waive this contingency? I did have a case that was related to that, where I represented a mortgage broker on that dispute of waiving of the contingencies. So, you just want a paper trail.
Yeah.
I mean, at the end of the day, you want to make it crystal clear, what we're waiving and who gave you that authorization and green light to do that.
Of waiving it. I think too often buyers are like, oh yeah, that sounds good, I'll waive it, without knowing the severity of what that could mean.
Yeah. As a buyer, your contingencies are everything.
Yeah.
And right now, I mean, so you probably know better than me. I mean, are people going all, waiving their straight off the bat, no contingencies, offers?
So the contingency that's most common to see waived is the appraisal. And I think largely it's because a lot of agents are going to try to play, their own version of chess with the game of like, okay, we'll rush the appraisal into our inspection and then we'll walk away under inspection because, investigation is a pretty loose contingency overall. But I'd be curious how, if it doesn't appraise and they already remove that, especially with FHA, if that gives them cancellation rights under the loan. I would say we are not seeing, it's not 2020 anymore, we're not seeing inspection waivers, appraisal is kind of, but no one's really waiving loan or inspection at this stage. It's very uncommon.
Well, when it was happening, I was like, that's pretty reckless. Because if you have a loan and you're going to waive your loan contingency, what happens if you don't get a loan?
And I would imagine the person who probably carries the most liability in that sector would probably be the agent, because most people are going to be like, they told me to do this to be competitive. So that's probably a big, thing, a big risk factor, right? If you're an agent and you want to triple check that your clients know what it means, and probably in writing. What about if there's a dispute between a buyer and a seller and it doesn't appear that they're going to be able to work it out, and the seller won't release the deposit? So in one theory, that escrow is still an active escrow. What would the validity be if that seller goes to a different escrow company and opens escrow with another buyer? And what would that potentially result in?
So I guess we're really talking about the deposit, right, and liquidated damages kind of issue. If there's a clear cancellation, intent from, let's say, the buyer, right? The buyer has communicated, listen, I want to cancel. Then I think the seller legally can go open another escrow, even though the funds, the deposit is still being disputed over, damages are still being disputed over. I do know from experience that some escrow companies, right, they're like, hands off. They were like, wait, you need to close that other escrow before I get involved because I don't want the extra potential legal headache, of walking into a mess, which is probably prudent, for an escrow company because they're not charging a ton, so they don't want to do extra work because of some dispute. But I mean, I think the issue of the deposits are generally pretty clear. If you've waived your contingencies as a buyer, then you've lost your deposit. So, there could be arguments of whether the seller has, not fully cooperated, right, or not, operated in good faith on some level to, frustrate, the contract or something. So, maybe, there's some stuff there. But the generally, and that's a hard pill to swallow, right, for buyers. I waive my contingencies, and now, but I want my money back.
Now I want to walk away. Is there any true definition of liquidated damages? And what I mean by that is, say you had buyer one was going to close in 30 days, they try to cancel in 15 days for $800,000. And they're trying to cancel, and then the seller accepts a backup offer, which is going to close in that same amount of time, and is offering $850,000.
So is offering more?
Yeah. So could they say, like, you didn't incur damages because this other buyer is paying more and they're closing at the same time, so your timeline didn't change? Yeah. Or is it pretty cut and dry that you removed your contingencies and that's the liquidated damage?
I think, to me, I think it's a gray area. I think it's a legal gray area because liquidated damages is generally frowned upon by the courts. It's liquidated damages are seen as a penalty, and really the courts want to make people whole, right?
Yeah.
So you were damaged, right?
Yeah.
So that person should get the money back. However, I'll say that arbitrators, I feel like, generally just say, listen, that's the liquidated damages clause. This is how the industry had set up, the damages to be. Case shut, and then you're not going to appeal that or anything. So, in practice, if you go through arbitration, I think you're going to end up losing your deposit. Yeah. Under the liquidated damages clause.
So it goes under the whole thing. It always depends on the situation, but for the most part, if you're looking strictly contractual, you've probably forfeited your deposit once you've waived all your contingencies.
Yeah, I think it makes it a really easy job for the arbitrator to just be like, that's what the contract says, that's what you deposited, case over. I think, maybe arguing what ends up getting more difficult is when you have sellers who are asking for more than the liquidated damages, or asking for actual damages, I had to end up selling for less, right? And so now, even though there's $40,000 in deposited in escrow, I need $100,000.
Okay.
I think that's tough to prove. Or on the other side too, if you're a buyer and the seller cancels, and then you have to buy another home, and now your interest rate goes up. I think those are all interesting questions related to damages.
How does that typically play out? Because how at least the purchase agreement reads is it kind of caps it on residential 1 to 4 at 3%. So how does that typically play out if those damages are significantly higher than that 3%?
Yeah, I think if you can prove it with substantial evidence, and show that you really did not, you did your job, you mitigated damages, right, to the best of your ability, that arbitrators will go ahead and actually seriously consider those extra damages.
Really?
Yeah. Especially, it depends on case by case, but I think from an arbitrator's perspective, you're probably looking at the reasonableness that the breaching party could have foresaw these damages.
Okay.
Right? So it's not totally out of the blue.
Yeah.
So if it's reasonably foreseeable, then I think an arbitrator, and it's documented and the other party mitigated as much as possible, I think an arbitrator is probably going to give those extra damages.
Yeah. Going back to what we talked about a little bit earlier with disclosures, how would one perceive the lack of disclosure if there's confidence that the seller may have not known about it? You mentioned foundation. Well, a lot of sellers are not crawling into their foundation crawl space. They may not know. And if the buyer didn't get an inspection, could they still come back and be like, well, you should have known because you've lived there for 20 years? Yeah.
Those are hard, right? Yeah, I think those are very hard cases. We have one case right now, actually, where the seller is claiming they didn't know. They lived there for 10 years, and they're claiming, we don't know. But our argument is going to be, well, there was a lot of rain during those 10 years. We did experience a lot of rain recently, and we're going to have an expert put on saying, well, it's basically impossible that if you were the owner for 10 years in this neighborhood, in this city, with these soil conditions, right, that you wouldn't have seen or felt some kind of effects of the foundational issues, right? So, meaning the walls wouldn't have moved, paint wouldn't have been displaced, maybe concrete walls wouldn't have broken, that wall that has a line through it definitely was on your watch, kind of.
Yeah. Is ignorance a defense?
Ignorance of
going back to that land movement thing, first place I think about is Ranchos Palos Verdes right now with all that land movement, and it's like, if a seller's like, oh, I just didn't investigate what's happening with my house, but it's like, the other 10 houses near you just slid down the hill, you're being negligent here, and you're just arguing that you're ignorant to what happened. Yeah, no, I think, in that case, in that context, ignorance would not be a defense. Yeah. You know, it would have been, you know, something that you should have known about. Yeah. You should have known about and should have investigated. I think, again, it comes like that example of, you know, you should have noticed that your wall suddenly had a crack in it. Yeah. And that you didn't, you know, when you bought the home, it didn't have this large, you know, separation, and now it does. So, yeah. Okay. Yeah. I don't know how to even phrase this question, but, you know, I think about there's so many agents out there who may put, you know, they write these offers and there's typos all over and there's mistakes on them, and who's care, like, how much of the liability is just on the agent, but how much of that liability is being passed on to the client without knowledge, because they still signed this contract at the end of it. You know, I had an offer the other day that came in where they put their financing just under, like, the whole wrong term and where it goes on the contract, and I'm looking at this and I'm like, if we went forward with this and we tried to enforce it, we have a contract that we can enforce as the seller. Yeah. But when is it shared liability, and when can it strictly be buyer or agent? Yeah. And those are really, I think, tough questions, you know, because, you know, as the party, as the buyer, I mean, your agent is literally acting as your agent. So ultimately the buck stops with you, right? Yeah. Whatever you sign, you're responsible for. Yeah. Your option of recourse is then to, you know, sue your agent, you know, and indemnify, sue them and be indemnified for, you know, them filling out the paperwork incorrectly or giving you, you know, as you know, agents have fiduciary duty. Yeah. So, I mean, that's a big responsibility. You are, you know, you're basically required to fill out that paperwork as if it was your own. And so if you're not, then you're failing on that. And as a buyer, you know, you could sue your agent and for not only negligence, but under the fiduciary duty breach, recover attorney's fees. Yeah. So it's a big deal. So they would still have that right for the attorney's fees as well. The attorney's fees kicks in under fiduciary duty. Yeah, because I was curious about that, because technically speaking, a offer and a purchase agreement is really between a buyer and a seller, and agents are there to help, you know, move it forward and assist in it, but it's between them. But I guess what you say makes a lot of sense, because they're counting on with reasonable expectation that the agent is acting as a fiduciary with reasonable skill. Exactly. So then, like, what I would do if we had that kind of case, we would just have to hire another real estate broker in the same area that knows, you know, that is sufficiently experienced to qualify as an expert. Yeah. You know, and just be like, is this the standard? Did this broker breach, you know, the standard of care and breach their duty, in your opinion? And I think that's, like, massively valuable to a judge or, you know, arbitrator in making their decision. Yeah. So speaking about fiduciary duties and where that line is going to be drawn, we have a lot of movement in my space, you know, with buyer agent commissions and the whole NOAA settlement. And one of the things that is now entering into these listing agreements on a large scale is the ability for the listing agent as just a transactional agent, where they don't represent the buyer, but they act as a transactional agent. How do you think that will ultimately play out? Because it's quick to cross that line of, I'm just assisting in the transaction, to, I gave you a piece of advice. Yeah. I think that's very, very hard to, you know, separate the two. Yeah. You know, because we've been so used to agents have all of these responsibilities for buyers. To now say that an agent is purely helping in the transaction, and I mean, there's still going to be, you know, like, I mean, they're going to still be a representative of you. You know, there's no real way of, like, you know, I think this is, I had a judge tell me one time, you know, you're either pregnant or you're not pregnant, you know? Like, there's no middle ground here. And I think that's maybe what they're trying to do, right? They're trying to separate things where it's kind of impossible. You know, either you represent the buyer
or you don't.
From a liability standpoint, would you say an agent even explaining the contract is crossing into beyond a transactional? Like, is an agent really just supposed to be like, here's a blank form, figure it out and send it to me? Or can they at least explain, like, this is what this paragraph means, and like, without giving guidance of here's what you should do, can they explain it, or is that crossing that line?
Yeah. I think, I mean, for the agent's point of view, I would want to get it all in writing, you know. I mean, this is, you know, in my industry, it's all paper trail is everything. You know, so yes, I would say, you know, explaining more is better for the agent's protection. And, you know, it's probably just good practice, you know, if you want to build a good clientele base, you know, that you're known as someone that, yes, you're here to do the transaction kind of only, but you're really fully explaining, you know, what it means.
You're acting as more of a dictionary of definition for them.
Yeah. You know, if you know something well, you can say it simply. And so, you know, and I think in both our industries, it's important that we simplify the realities of these contracts and terms.
But the second you go from saying, hey, the purchase agreement says loan contingency 17 days. The second you say, hey, the current market standard is 14 days, you cross that line, right?
Now you're advising them as an agent.
You're giving a little bit of information.
I would say you really would, like, it would just be minimal. This is what this means. Without any advice.
Beyond that, I've crossed that line.
Exactly. I'm not counseling you on anything.
So now if we go into that trajectory of, you know, representing them, and you represent seller, we're going down the path of dual agency. I'm sure you see a lot with dual agents, because I would imagine that's a sticky point for anyone. Do you think there's really a way to be a fiduciary in dual agency?
Yes. I personally don't like it because, you know, and maybe that's just over the years of being an attorney, you know, we're trained that it's such a hard no, right? You can never represent two parties, right? And provide them both the attorney counsels, you know, the level of service that they need. But there is also, and I understand that, you know, and this has emerged especially in divorces, where, you know, you'll hire one lawyer, you know, to kind of manage to mediate between both parties. And so in that context of being kind of a mediator between two parties that want to get divorced, I could see that it works. So, you know, but as a dual agent, I mean, you're still technically, you're not mediating anything. You're kind of negotiating against yourself.
You're still on both sides of it, and it's how you handle that.
So I think it's very, very difficult to do. And I guess just there's all kinds of, you know, legal landmines there. But for example, one of them would be, you know, the inspections, right? The repairs and inspections, you know. So if your buyer comes in and there's a bunch of repairs that need to be done, now what do you do? Because now you have to negotiate against yourself.
And even before you even get to that stage, you represent seller listed it for, say, $1 million. Buyer says, well, I want to write an offer at $950. How do you, I mean, is it simply like, hey, whatever you want is what I'm going to do, and like you can't give any advice on it because you know where the seller's position is? Like, is it kind of at that stage more than anything you're kind of moving into a transaction of like a transactional agent, like a mediator, where it's, hey, I'm not going to give you input. I'll do what you want, and I'll take it, and I'll present it to them, and I'll respond with whatever they want.
I mean, and that's how it should be. If you're a dual agent, you really can't give any kind of strategy advice to either side.
You can't be like, oh no, you need to come up 20, and then go to the seller, hey, you should come down 20. It's just like,
I mean, I guess you could say this is what the industry, you know, would maybe allow for, you know, and this is maybe what you could get away with in a general sense. But you're basically kind of just being telephone and mediator and just saying, listen, I just want to make this deal happen. And so, you know, what's your best, you know, offer, right? And what's your best that you can do?
And so let me ask this, and who knows, maybe you're going to say I would never work with anyone on it, because you have a great background knowing real estate, knowing the contracts. If you were to go buy a property, would you want to work with the listing agent, or would you want someone on your own side?
Oh, 100% on my side, yeah.
Yeah, so you wouldn't even go to try to get the dual agency, because you're like, at the end of the day, you probably won't have the best result.
Yeah. And this also goes to what I like to tell people. I'm an attorney, and if I get into if I have a legal question personally that I'm dealing with, or a legal issue, I'm going to hire a lawyer, right? Like, because I don't want to be that close to the issue, and to be that I'm not being objective. I'm missing something.
Yeah.
So, and it's common, as lawyers, we will hire other lawyers to represent us when we need them, right? If we're going through probate or something, right? Let's say if a family member of mine were to pass away, I wouldn't represent myself or my family. So, in the same sense, if you're an agent, if you're a non-agent, if you're just a regular consumer, you want somebody that's fully representing you and that really has your best interests at heart and can give you strategic, advice.
And objective.
And hopefully objective advice, right? And hopefully, this is someone that you can, that's been maybe referred to you because they did such a good job with the other person, the person that referred them. And with this new NAR settlement and everything, the question is, what's that? Are you willing to pay the price for that?
Yeah.
And I think you should be.
Yeah.
I think as a buyer, this is a massive decision, and with all of the potential, things that could go wrong with it, if something goes wrong where you could end up paying, $50,000, you lose your deposit, right?
Yeah.
Maybe you lose your deposit, or you get in a situation where now you're responsible for additional damages and attorney's fees. Just paying an agent for their time and their specialty, super valuable. And then also the negotiating. Maybe they save you $50,000.
Yeah, can they also help in that aspect?
They paid for themselves, in just the purchase price.
Yeah, it's going to be similar to if you had to, if you were to go sue someone, odds are you're going to do better in that litigation if you have an attorney versus if you're
1,000%.
filling out the paperwork on your own.
1,000%. Again, I would never represent myself.
Yeah.
I would personally pay the $40,000 for an attorney to help me in my own dispute because I know the value of it.
Yeah, and you think having someone who can look at it from outside looking in without that emotional element is probably more valuable than a lot of people consider.
Exactly. Yeah. I mean, and so we did buy a home recently, and I got all these credits, and I got a lot of benefits, and so those things add up. If you're just a regular person trying to negotiate. I also think it's funny. I mean, I understand for sale by owner, right? Trying to save money and all that, but I'm like, you're probably at the end of the day not saving much.
And the reputation is for sale by owners tend to be one of the highest litigated transactions out there as well. Because they,
I would not be surprised by that fact. Yeah.
Because it's simply the fact they're going to try to find a way, and it may take them longer to get to that contract, and then once they're in contract, they may be less likely to disclose everything because they are so worried about what if it falls apart.
Yeah.
So they don't have that outside perspective of helping explain the risk factor of these non-disclosures.
Yeah, that'd be very interesting to see the statistics on for sale by owner and how many actually close. And I think I would assume the time on market is forever longer. It's probably 3 times longer than with an agent.
The last stat I saw on it is it takes 64% longer for sale by owner to sell, and they sell for 87% less than if they sold on open market.
Yeah. Not surprised at all. I was going to say something else about the attorney. That by the same token, I think that as soon as, and this is where we get our clients, and it's kind of unfortunate they come to us later than I think they can. But as a consumer, as a buyer or seller, as soon as you feel like in your gut that anything's wrong with the transaction, or maybe you're not having the communication that you'd like to have with your own agent, that's the perfect time to have an attorney, step in and kind of like clarify things. Yeah. Like, right, explain your rights, reaffirm that, everything's good and going on track. I think as real estate attorneys, we can help get that transaction to the finish line if we're called on sooner rather than later. And again, our fees are very reasonable at that point than after the fact. Trying to unwind something, trying to sue for damages after the fact, that's when the attorney's fees costs get to what people fear of. Like, oh, attorneys are expensive. Yeah, well, when you have to resort to that point.
When you come in a little too late, that's when they get rid of it.
When a lawsuit is needed, then it's going to be expensive. But other than that, we can, hey, 3-4 hours, we can, flesh out a lot of issues.
I'd also imagine at least that it would be advantageous for the client, like you said, that second they have a weird feeling, because it's either going to confirm their feeling is correct, or it's going to give them an outside perspective of, hey, I'm not getting a commission from this, but what you're being told is accurate information. And I wouldn't disagree with what they are recommending.
Exactly.
So it's going to give them peace of mind in either direction.
And that could be invaluable, right? Because especially for people that maybe this is the first time they're buying or first time they're selling, it's a very stressful, situation to be in. I mean, it's tens of thousands of dollars. You don't know what any of these forms mean. You don't know what any of these deadlines mean. The loan documents are massively long. And so really, at minimum, if all you're paying $2,500 for, $3,500 for is for peace of mind and reassurance that you're getting the best deal possible, right?
Yeah, best deal and fair representation.
Exactly.
Because I'd imagine there's a lot of unfair representation that you probably see out there as well. What is the number one thing? Is it going to be fight over earnest money deposits? Is it going to be disclosures? What is kind of the biggest thing that just keeps coming back to you where you're like, this is what we see the most of?
I would say it's probably a split between, breaches, just straight up, one of the parties is trying to back out.
Okay.
And then the failure to disclose.
Okay.
Is the other one. Yeah. The failure to disclose is just so huge. We've seen a lot of issues with water damages, permits, and this ADU isn't permitted, and so like one case that we're working on right now, the real estate agent was a dual agent for both. So already bad. And then
starts that way.
And then he's just like really selling my client, who's the buyer who ended up buying this property, really selling them hard that this little back room is that she can make money by renting it. Yeah. And so she doesn't know what is legal and how you need a permit, you need to apply to the city to get, a certificate of occupancy and all that. So she ends up not doing that either, and she just rents it to this family relative.
Okay.
That becomes a headache. She ends up needing to evict them but that's expensive because there's no permit.
Yeah.
So this agent just sold her a dream of, hey, rent out the back unit. Yeah. And so that's a big lawsuit.
I would imagine that's a very sticky one too.
Just don't do it. Dual agent, and then really telling someone to rent something where that it's not permitted. At that point, I would say and I've been in rooms where I've asked agents like, how often do you pull permits? And they're all like, I never do that. If you're going to be a dual agent, that's probably the one time I would highly recommend to pull up permits, verify. And this could be as easy as just calling the city and just saying, hey, I just want to know like how many rooms are permitted, right? Yeah. And if there's 5 rooms that you see visually, but they tell you there's only 3, you got a problem.
Yeah. And it's unfortunate because I think agents at a minimum could, even before they get to that stage, check title.
Mm-hmm.
If title says it's a 3-bedroom and you have 4 bedrooms and an ADU that has a bedroom, you know that something's off.
Exactly.
With this one. It gives you reason to dive deep.
Yeah. Check what the previous listing said, right? What the tax assessor, says.
Mm-hmm.
I would definitely triple check all of those as a dual agent. Arguably, as a dual agent, you're going to earn your commission because of all the double work that you're going to have to do.
And you should be doing the double work.
You should be doing the double work.
It goes back to the fiduciary responsibility of you have that right.
Yeah.
You need to provide that to both clients.
Yeah,
with the whole fiduciary aspect and the dual agent aspect, the pulling of permits, it's interesting you bring that up because it's not just agents who may say they don't pull permits, but brokers encourage their agents not to pull permits. And the theory of it is, well, if you pull permits and you get, say, 12 permits on a property, but there was actually 13 and you missed one, you're liable because you didn't give them all 13. Is there a case to be made that the agent did everything to the best of their ability in gathering the documents? Or how would that play out?
Sorry, I missed that, but you were saying like you're pulling these permits and giving them to the other party?
Mm-hmm.
Okay. Yeah, I mean, that's definitely probably, could be potentially be a problem. And maybe the safe way of doing that is just disclosing, hey, this is what I got and this is where I got it from. Please do your own due diligence, to verify this information. I'm just doing this as a courtesy kind of thing, right? And
I can't guarantee the accuracy of the permits. This is what was provided, but if this is important to you, make sure you go down to the city and gather what they have on file.
Exactly. Yeah, I would go the extra mile in explaining how you got those permits and who you talked to. What was your process, right? If your seller is like, oh, I got these have been stored in my garage for the last 20 years, here you go, then that's what you give the buyer, right? Hey, this is from my seller, this is what he has, but of course you should do your own check.
Yeah. On disclosures, and this is just my own pure curiosity to be honest, is what if the seller has dementia, Alzheimer's, something that impacts their ability to clearly give accurate disclosure? What is the best way for them to be safeguarded when they do fill out the disclosures?
Well, I mean, I guess thinking outside the box is just, working with family or friends, that know that individual. Usually you're talking about like an elderly individual. And, I think this problem comes up also with in probate, right? When, a relative who hasn't lived at the home, maybe they lived there when they were a child, right? But now they're the trustee and they're signing off and everything. Again, I think it would just help for, because you never want to welcome litigation, so asking around from family and friends, or anyone else who's lived there for whatever information they can give, going through receipts, right? So if they hired contractors, right? This person with Alzheimer's hired contractors, 5 years ago, what did those contractors do? Maybe call them up. So I would say, you just to be safe, do a little extra legwork.
Your recommendation would be to dive deeper and
investigate and try to gather what you can, because you're just asking for a lawsuit, even though you might win, even though you might be like, hey, I have a good defense. I mean, my client wasn't withholding on purpose. It's still expensive, right, to fight that lawsuit.
Would it cross HIPAA laws to disclose, hey, we filled out to the best of our ability, but recognize our client does have dementia? Like, does that cross a boundary by disclosing that fact?
I think I wouldn't go ahead and disclose it without full authority from the client. Because it is a sensitive health.
But if they went and put it in their own disclosures, it's them giving up.
Exactly. If they do it, great. But if like the other agent calls, it's like, I want to know more about this dementia. How long has he had? It's like, listen, whatever my client is comfortable with conveying, that's it.